.7, 95.1 FM, The Light.
The following is a paid program. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views of Radio 1, WTLC AM 1310, 92.7 FM, 95.1 FM, The Light, and its management. And now, to address the legal concerns of our community, AM 1310, The Light presents Legally Speaking. Here is today's host.
Good morning for all of our folks on our local radio station, WTLC 1310 AM, 92.7 FM, and 95.9. Thank you for listening in today. Also, the people that watch us on YouTube and Facebook, thank you for being a part of our program. Today, we have some important news, a lot of different things that occurred. And I'm going to have Attorney Milton Grimes going to call in and talk about the Ahmaud Arbery trial. The jury selection process went this week. But the most important thing that happened that was historic, we had some national elections this week, and the Democrat didn't do as well because they did not get voter turnout. But the one significant thing that a lot of people were critical of was the Democrats failed to pass the president's key legislation. And finally last night, in the middle of the night, they did pass by a narrow margin, but it got passed. And it's a $1.2 trillion program. But there's something that's very significant about this. And first, only two of our congressional people in the state of Indiana voted for it, Andre Carson Mervin, and all the Republicans voted against this legislation, which is just crazy. And the reason being, this legislation is one of the most historic legislation we've had since Social Security. Let me explain why. This important legislation will allow for us to have electronic charging station all over the country. They're doing about $7 billion. They're going to have maybe 100,000 of these charging stations. So now is the time for you to start looking very closely at electric vehicles. Imagine every year you'll save about $4,000 if you travel a lot on gas, oil change, and tune-up and things like that by having an electric car. And the government also give you a $7,500 tax credit for it. So now think about this. You can now be able to get your car operational for free. The government's going to provide charging stations all over the country. And I said, man, now is a good time to go out to try to start looking at electric cars. I'm just hoping and praying that General Motors, Chrysler, and Ford have a good amount of the electric vehicles. I'm not a big fan of Tesla. I don't like their social policies, and so I dumped my stocks in Tesla, even though it was making me a nice return. I didn't like their social stance, and therefore I'm not going to buy their cars. On the other hand, though, I'm a big supporter of the traditional American-made manufacturers. That's where all my friends work, at General Motors, Chrysler, and Ford. And so I always want to support those traditional American companies because I understand how important they are to our local, state, and national economy. But that was just part of the program. The other part of this massive legislation is that they were also going to provide for money for construction and repair of all our bridges and highways. The thing that also caught my attention was the internet component. They're going to expand broadband to allow internet for everybody. And under this legislation, internet's going to be free. And I was thinking about that. If I can get internet in my home for free, then I don't need to have a TV contract with AT&T Xfinity. If I get it, the broadband over the air by the government, I'm going to the government internet. And that's going to save me a substantial amount of money each year because I'm a TV junkie and I use the internet on a regular basis. And I think that most people do. But if the government provides it, I think it's just a wonderful thing. And it's going to result in a lot of savings. Also, it gives us, particularly minority community, just think about this. All our kids have access to free internet services. That means that we have the ability to further educate ourselves And the information on highway is so exhaustive in terms of information. It's just unbelievable. Now, you could live your life on the internet. You could order all your food. You could take your classes to educate yourself through college and university, high schools. You could have supplies all delivered to your house. And so the internet is a wonderful thing for all of us. And I'm just so thankful that we've had this massive legislation that would address a lot of the societal needs. What has been transpiring in our country is that we've had a radical departure between the haves and have-nots. There's been a widening gap between folks who make a lot of money and folks that are living in poverty. And so what we're trying to do is that we're trying to give everybody in this country an equal opportunity for the wealth of the nation. The one thing that we learned, I think that was really important, is that we saw an American hero buried this week, Colin Powell. And our condolence goes out to his family and friends, but he transcended local, state, and national politics. He was a Black Republican that was the model citizen. He fought hard for civil rights and equal justice for all. He was a brave commander, smart, intelligent. He came out early and, as a Republican, supported Obama because he saw something that a lot of people did not articulate. That is, that he was a transformational leader. And we saw a change in our country with the election of President Obama. For the first time in American history, we had 13 United States attorneys, and the Attorney General was African American. And we had cabinet members, and we had Blacks at all levels of government. And the appointment to the federal courts, we saw 20% of the appointments were minorities. It's never happened in American history. So now, then we had 4 years of Donald Trump, and we saw a radical reversal. Now we're back on track again to correct those wrongs. But throughout it all, Colin Powell was a steadying force that allowed for us to take a critical look at race relations in our country. We saw a person who was respected by all, and he did a great job. Now, one of the issues that we're going to discuss today, I want to get my good friend John Bartlett on today because he invited me to an event last night, and what was important about it is that he sponsors legislation to recognize soldiers who did outstanding jobs. And it was an amazing event. And hopefully he can call in today to explain to it, because I like to see some African-American honors. I know that we have heroes in our community, and I want to make sure that they also be recognized. And so, I want you to follow with John Bartlett, because I think it's something that a lot of folks out there that have relatives who have been in the military at any time. And I want to recognize their outstanding service, and I want to make sure that they be also inducted in the Military Hall of Fame next year. Now, this week, we saw with our own eyes, if you watch the Ahmaud Arbery trial down in Georgia, we saw how important it is for you to participate in the jury trial process. We have a community that has a substantial amount of African Americans. And I saw the community was about 40% African American, but they have a jury trial they got 16 people and only one Black person. So that does not represent the diversity in that community. But the defense attorney in this case struck all of the Black jurors except one. And I was troubled by that because this whole process of jury selection was first adjudicated by the U.S. Supreme Court in 1986. In that case, 1986 case, they determined that it's called Batson versus Kentucky, that the exclusion of Blacks from the jury panel violated the 14th Amendment right. And so that was prosecutor type misconduct. And we saw that in the Mississippi case. The gentleman was tried almost half a dozen times by a discriminatory jury selection process. So in this case, I don't know how it's going to turn out. I watched part of the trial and it was just too much to watch because the defense attorney, instead of doing an opening statement, did a closing argument. He started talking about what the law is and what you should follow in terms of law, which was impermissible. Only during the closing argument do you talk about the law, because the judge, when you do a jury trial, here's how the process works. You do preliminary jury instruction that give the jury the framework of the trial. So you start out with the instructions tell you what the issues are that be adjudicated by the jury. And then they give you some preliminary instructions like you can't look at TV, you can't participate in social media, you can't discuss the discussions of juries outside the presence of the jury room. So when you start a jury trial process, you're somewhat sequestered and you're not allowed to talk to anybody outside of the jury process. If you do, you can be held in contempt of court. Now, this is very important because these cases like Arbery and all these things are very important. And so when you start this process, it's a serious process, but the jury pool have an extraordinary amount of power. They have the power to right or wrong. And in this case here, it was based on the clear video evidence, it was murder. And hopefully the jury returned a verdict that consistent with the evidence. Now, before I talk about that, I need to also give a special congratulations to those jurors last night who returned a verdict. I got the information late last night on my news feed that the police officer who beat up the Black teenager at Shortridge High School was found guilty last night. It was Officer Robert Lawson. And what happened is in 2019, the officer went to the school and the teenager kid had been a victim of some gang at the school. And so the IPS, what they did was, sometimes I think IPS is a dysfunctional institution. So they kicked the kid who was the victim of the beat out of school. And so an adult had to come pick the kids up. And so when this occurred, Officer Larson showed up, and for reason not fully known, is that there was a issue in which he punched and kneed the kid and tried to harm this kid. And he fabricated the incident report. And luckily, there was video footage to show exactly what happened. It was the type of case whereby 99% of the time, the young Black teenager will be convicted of a crime or he'd be battered and bruised and nothing would be done. But thank God that we have a great prosecutor, Ryan Mears, who then took the case on, and their office did an outstanding job. And last night, Robert Lawson was found guilty. On Wednesday, he was found guilty of official misconduct, perjury, and false informant. So he found not guilty of battery resulting in bodily injuries, and a mistrial was declared on the obstruction of justice charge. So it's very important that he be held accountable for part of that. And so apparently, I'd like to congratulate jury, at least on finding him guilty on the official misconduct and perjury and false informant charge. So thank you very much for doing your duty. Now, back to the Ahmaud Arbery trial. We have jurors that were selected. In this case, was deselected, and unfortunately, they allowed the defense lawyer, I thought, too much latitude in terms of getting rid of jurors. And the problem that we see is that the jurors on that case, when I was watching part of the evidence, I was concerned about how much latitude the court gave the defense lawyer. And because of that, it could affect the outcome. Now, could you imagine that you have a relative who's out jogging and get hunted down and murdered in broad daylight? I've watched the opening statement, and they painted a picture as though these vigilantes were some type of hero. And without real proof, they were claiming that somehow this house that's under construction, that they were concerned about the person breaking in and stealing something from a house under construction. Now, the problem with that theory is, and I hope the prosecution pick up on this, is something very important. When watching the evidence in the case, the gentleman had on jogging clothes and he's out running. And the defense lawyer is trying to make this as though he's somewhat of a threat. So if you were going to try to go and burglarize a home and take something of value that's under construction, you got two issues, size and weight. So if you're going to steal something, are you going to run 5 miles carrying a board, TV or something? I mean, the idea that somehow he's burglarizing a home while having jogging pants and stuff, nothing that he can conceal, it will just insult him. And when I watched the argument, I was trying to figure out this defense lawyer should object. And And I was
Hello.
concerned about that because there was not evidence of that at the time. Oh, Milton, are you on now?
Hello,
Okay.
Nate. Yeah, good morning.
Well, thank you for joining. Did you watch, Milton, I watched part of this is Attorney Milton Grimes, the famous lawyer out of LA who represented Rodney King. I watched part of that trial and I was incensed in terms of how the judge and the prosecutor allowed this defense lawyer to make this opening statement. He was trying to paint this guy who got murdered as a criminal burglar. In fact, I'm thinking, well, how in the hell can you burglarize something with short pants, sweats on, sneakers, tank top? In other words, it's absurd. What could you steal and run for 5 miles with at a house under construction? Could you take an air conditioner or heating system? Then how are you going to carry it? He wasn't in a car. He wasn't in a truck. Didn't have a van. Didn't have a tow bar or anything. Was that argument effective? What do you think about it? Hello?
Okay. That was the defense attorney's opening statement that Aubrey committed a burglary.
Yes. So when he gave his opening statement, he did this PowerPoint and he did something that I thought was inappropriate. He started telling the jury what the law is on self-defense, what the law is on probable cause, what the law is on citizen right to arrest other citizens. And I just thought that was inappropriate for opening. He was making a closing argument, but more disturbing is that he was giving an opening statement about this guy being a prior burglar to this house under construction. Only one big problem with that. They didn't identify a single thing that he had stolen.
Right.
And I was
right.
Yeah, go ahead.
Yeah, I mean, as a criminal defense attorney, as a civil rights attorney, I can see how the defense attorney would want a jury to believe that he had committed a crime and he was escaping from that crime, even though I don't think that justifies killing anyone, but it's to put him in a bad light. So I can understand how you feel it was inappropriate. There should have been some objection to it, that there was no proof of any burglary. There was no property taken. He wasn't carrying a piano or refrigerator on his back, and it was not even an enclosed structure. And in my understanding of the law, to commit a burglary, you have to commit an entry, unlawful entry, with a criminal intent, usually a felony, into a dwelling or building. A construction is not a building yet. It is not. So I don't know how you get into those parameters.
Well, I was concerned. I think that was a bad lawyer. The TV conversation. Here's one of the problems I have. You have people on TV that don't do actual jury trials. I've done like 188 jury trials. So they do 4 or 5 jury trials. They get on TV and they become an expert, not realizing what these lawyers were doing. I thought was borderline professional incompetency. When I watched them allow them to talk about this, I said, look, you dummy, make an objection. Is a 403 type objection or 401? In other words, it's irrelevant, it's prejudicial, whatever. But they don't.
Right.
I was disturbed by the prosecution lack of objection to an argument that I thought was clearly erroneous.
We call it a 402 hearing that's done before we get in front of the jury. They admonish you what you can and cannot say because you don't have any evidence to substantiate that, or the law rules against that. So yeah, I agree with you, Nate, about that. But I was thinking, waiting for this call, Nate, this morning, about the various cases I've participated in and that I know about where the prosecution did not object to the venue that the matter was tried in, just like in the Rodney King case. The prosecutor said, I'll try it anywhere. And the defense immediately said, we can't get a fair trial in L.A. Let's take it to Simi Valley. The prosecution said, okay. They didn't fight against that. And Simi Valley is the graveyard for retired police officers from L.A. It's known for that. So you have a police-friendly jury. So the outcome of the case could have been expected. Not guilty of these officers. Someone. Same thing down there in Georgia. I don't know whether they protested against the venue there. Hello?
Keep going. We'll get to Imhotep in a second, Milton. I didn't think that those prosecutors were very strong advocates. That was my problem.
They were what, Nate?
I didn't think they were very strong advocates, litigators. I just didn't think they were.
Nate, you keep saying that, and I'm trying to tell you that happens more than it doesn't happen. I saw the prosecutors in the King case. They didn't put King on the stand. He didn't testify in the Simi Valley case. They didn't put him on the stand because they said he was too angry, because they didn't spend time with him. The prosecutor didn't know King had been interviewed by Internal Affairs until I told them, well, he was interviewed by Internal Affairs. Now, that was after the Simi Valley trial. That was after the federal criminal trial of the 4 officers when I got the discovery. I read a report that said the Internal Affairs investigated King 11 hours after he was arrested at the jail. The prosecutor said, oh, no, I don't think so, Grimes. I said, I got a report right here in the 4 boxes of discovery that I got from you. He said, oh, let me check. Oh, yeah, I got a package here, got internal. Let me open it. He opened it at that time and said, oh, yeah, here's the tape in here, and here's a 3-page report. I said, yeah, they interviewed King 11 hours after he was beaten. The prosecutors in the case did not know that, and it was after the trial. So don't look for excellency in these prosecutors during these cases.
That's terrible. Okay, we'll take Imhotep now, and then we'll get back to this. Imhotep, you got a question or comment for us today, sir?
How you doing, Brother Nathan Grimes? Thank you for taking my call. And there's the same feeling here. Well, I'll get to that in a second. I had 2 questions for you, and then I'll one, doesn't seem very odd, and I guess it's par for the course with the behavior of the judge in Wisconsin, disallowing the victims to be called victims, yet they can be called rioters or looters. 2, have you ever, any case, criminal case, I would say, per se, high profile or low profile, have you ever seen a black defendant have 11 black jurors and 11 black and 1 of an other? Because it seems that white defendants, especially in high profiles, I forgot what, I think Amber Geyer had 10 and 2, the police officer down in Texas. Derek Chauvin, that was a little bit more fair. I think that jury was composed a little bit better. But have you ever seen a black defendant, high or low profile, get 11 black jurors and 1 other? And then the same issue that you all are talking about now is what the Morrell family and Brother Jabu talked about with the Newby case. Mr. Attorney Grimes, understand, we've got a case going on here where a young white gentleman killed a guy. There was a lot of stuff going on with the Florida protest. He said he was pushed down. He looked up. He shot and killed a guy. The guy was unarmed. Brother was unarmed. He was unarmed. The police, I guess, according to your colleagues here at this network, they talked about the case. They basically guiltied the victim because I guess the police were saying, well, if Morrell wouldn't have been killed, we would have arrested him for another gentleman who was murdered. But the judge just allowed that cop's testimony. That was not allowed into testimony, period. The facts remain, the gentleman was unarmed at that time, and a white gentleman killed him and claimed he was just pushed down. So they only had 2 blacks on the jury, on his jury, and they got a hung jury, and so they're going to have a new trial. So I'm trying to figure out how that happened. But those are issues we're having here, too. And
well, those
are a systematic process to get past basking, and I just don't understand it. So I'll listen to your answers off the air, and thanks for taking my call.
It's a very sensitive issue. If I may interject, Nate. I know he asked you the question, but I've done a number of these cases with this issue. You know, I protested against the jury in a death penalty case because we didn't have any blacks in the veneer, in the group of potential jurors. And the judge agreed with me and says, yeah, I think this young man is entitled to have some African Americans on his jury. The jury commissioner said, whoa, we can't just go out and handpick black folks. The Constitution only allows for a random selection of jurors. That means you have to take the people who have registered, who have car licenses, however that particular area of the country select jurors. And that's who you pick the jurors from. And there's a lot of politics that go into that I won't get into, but oftentimes you will have a panel that does not have African Americans or very many minorities in it because of, for one reason or another. So you have to take from that selection that's available. And oftentimes you end up with no African Americans in the veneer or in the panel because you don't have any to pick from. However, the defense lawyers usually are in the bad position. But in this case, you got white defendants and you got black victims. And so the defense lawyers are in a more favorable position because they feel that they're going to get more jurors who are sympathetic to their client, like police officers usually have jurors that are sympathetic to them, and when they walk in the court, they are presumed innocent, whereas if you're someone else, you're presumed guilty. But that's the society we live in. So it's up to the lawyers to do their homework, protest to the venue, try to get the case transferred where there be a fair, more diverse jury, and that's how you have to do this. In this case, the prosecutor should have been fighting for a more diverse jury and showing the judge that everybody in this area knows about this case, and we can't get a fair trial as the prosecution. They have a right to a fair trial too. But if they sit there on their ass and don't fight for that, then they get run over, just like what happened in the King trial in Simi Valley. When the cops were tried in L.A., you had a more diversified jury, and at least two of the four were convicted. But they weren't convicted in Simi Valley 5 months earlier or so. So it is relevant, and it is very relevant to make sure you have as fair and as impartial of a jury as you can get, but you got to work for it. It doesn't happen automatically.
Well, I thought that in watching both these trials, the one in Wisconsin, watching the one in Georgia, it's almost, we're at the point in our country now that we have to make sure that we have diversity in the prosecutor's office. Right. I was concerned when I watched the Arbery trial that either the prosecutors are not very good trial lawyers, or they have they're not sympathetic to the plight of the decedent. I was concerned about the fact that they allowed this defense lawyer to just create evidence. And like, for example, when they say that the place has been burglarized, but they don't identify exactly what they claim was missing. And more importantly, how do you say somebody's committing a crime and stealing something when there's no evidence he has anything, have the ability to transport anything? It was, the whole thing was just ludicrous to me, the defense, and there's no objection to all this inappropriate evidence.
Listen to me, my brother. I haven't studied it case by case, but I have definitely watched, observed, and studied about 5 or 7 of them. And 2 of them I was personally involved in. I've seen these attorneys, these district attorneys, not prosecute with zeal and hard work, Nate, for whatever the reason is. Either they're especially involving police officers. And now that you have a high-profile case like this, you would think that the prosecutors would be on their toes, fighting everything, fighting for everything, because they are being exposed and seen by the world. You would have thought that in the Rodney King. I hate to keep going back to something 30 years ago, but this was proof to me because I got the evidence of them not knowing very, very important elements of their case. And they prosecuted a case that ended up with cities being burned down across this nation, people being killed in cities across this nation, because one of the reasons they did not present a competent prosecution, because they weren't prepared. How you going to go into a trial and not know your victim was interviewed by Internal Affairs and there's a 52-minute tape recording under it? How are you going to do that and then decide not to put that victim on the stand. And it ended up with turmoil in our nation up until today. We still haven't gotten over that civil disorder. So I don't know what to say, whether it's planned or whether they just don't care, and they put these very inexperienced, incompetent, or attorneys who don't want convictions on these cases. You know, I read this book, Robert E. Lee, not long ago, and he talks about the narrative. Who controls the narrative wins the case. The book is entitled Robert E. Lee and Me. You heard me say something about it before, Nate, by
Yes.
Ty Seidule, Seidule. And he talks about today, there is a strong existence and presence of white supremacy, y'all, especially in the South. It is still there. They still say that the South won the Civil War. The Confederates won the Civil War. And that those are heroes that participated in the Civil War, and they're still naming bridges and roads and schools and churches after those Confederate generals. So don't get it twisted that you're going to get a fair trial with some of these folks in these, not just southern cities and towns and states, but throughout this country. We have racism still, and we have white supremacy still, and it permeates everything that we participate in. There was a judge in Virginia last year in Fairfax County who said he will never try another black man in his courtroom as long as all these white pictures are on the wall around his courtroom, because he knows that man cannot get a fair trial, whether it's subliminally, whether it's conscious or unconscious. That's, in his mind, is evidence that a black man can't get a fair trial in his courtroom, and he won't try anymore in there until all those pictures are taken down. That's what we got here. So ain't no need of pretending and scratching your head and thinking, well, we can get a fair trial for this boy and his family in Georgia with an all-white jury. Yeah, it ain't happening today. You want it to be, but I don't have the confidence in it. I'm sorry.
Well, you know, I think that
goes from DAs to judges to everybody. I'm sorry to interrupt you, Nate, but this is a passionate issue and subject to me. I'm sorry.
Well, I think that we need passion. We need somebody with your enthusiasm and passion in the courtroom on a case like this. And the defense got lawyers out of Atlanta, some really good trial lawyers. And the prosecutor, I thought, that should have gotten somebody on their case. I thought that they should have gotten a skilled black attorney to be on their side. I don't know why they don't think about stuff. That county is 30% African-American, you know, so mathematically speaking, there's no way that you should have had a jury pool of this magnitude in that county. I mean, out of 16, I mean, 30%, you know, that would be at least about 4 or 5, but to have one, I mean, it's insulting. But the other thing though, Milton, I don't think that the prosecutor, what I saw, was doing a good job. The commentators who were talking about it, I just thought that they were misplaced. I mean, they sound good, but I don't think they were accurate.
And so juries, they sense what a person feels about the case. They sense your integrity, your honesty, your compassion. They see it, they feel it, and if you don't show it, then you're showing a lack of conviction for your job. I don't care what nobody says. And if they don't feel these people are into that prosecution, then that's a little shy of convincing them of the righteousness of your cause. And if the defense attorneys are standing on the table and kicking over trash cans, you may say it's theatric, but it shows the feeling of the righteousness of your cause. And you need all of that in presenting your side of the case. It's just clear facts.
Yeah. Well, one other thing, Milton, because we're going to end a little bit short today. The commercial is going to be at the end, folks. The case in Milwaukee not Milwaukee, in Wisconsin, involving the 17-year-old who went to and killed those two people and wounded a third person. I did not understand the judge ruling and pretrial ruling that says that you can't call people who got murdered victim. Now we had a witness testify that the guy was non-aggressive, that the first guy shot did nothing to him. He just murdered the guy. And these witnesses that they were calling were friends of the shooter, several of them.
Is this the young kid that was walking down the street with the rifle?
With the automatic weapon.
Yeah, automatic weapon. Yeah, okay. And what were you saying about it? I mean, no, yourself, but what?
They said that the people he murdered, they could not call them victims, but they can call the people that he's shooting rioters and looters, even though there's no evidence that the people that he murdered had anything to do with rioting and looting.
The judge ruled that?
Yes, pretrial motion. Shocking.
I'm sorry, I'm not laughing at you or at it. It's just, that's what I'm talking about. It's sad to hear that. It's sad to hear that when I look at the Washington Supreme Court, who recently, June 4th, 2020, wrote that manifesto that I've read on this show several times, that they recognize that racism, systemic racism, has in the state of Washington, and they herefore recognize and admit to that, and they now have taken on the responsibility of trying to undo it and do something about it and give blacks and minorities a fair justice system. Now, these types of things you're talking about is the type of thing we have to address and fight against. That judge is wrong. I don't care what nobody says. What is a victim? A victim is someone who has suffered the wrong committed by a criminal. And if these people who got shot by this man can't be called victims, you're denying them a designation that has been given in our society to people who have suffered and been victimized by criminal acts of others. That's the clear definition of a victim. So how can he deny that recognition and that identification? And the DAs ought to be all over that. Hold up, let's take a writ. Let's go to a higher court, because that's part of our case. I remember the judge in the Rodney King case wouldn't let me use the N-word. I said, these officers called him the N-word. No, I don't see the evidence of that. They denied that. I said, but I got it. You can hear it on the tape. He said, well, I haven't heard it on the tape. So I had to pay $14,000 to a professor named Professor Pacon, who worked on the Exxon Valdez case on that oil spill in Alaska, to come to court prior to when I was going to present him and play the video of Rodney King's beating. And when you amplify it with the special equipment he had, you could hear the N-word reverberate all around the courtroom. I said, okay, Mr. Grimes, you can use the N-word in examining the defendants. Thank you. So you have to fight these people to prove your point and get your evidence in. And the prosecutor should have been fighting for being able to call these people who were killed and harmed by this shooter victims.
Well, thank you very much for your excellent commentary, Attorney Grimes. One of the top trial lawyers in the country. We'd like to thank him for his reviews and also historical perspective of this important issue. I'd like to thank each and every one of you, our audience. We're going to be off next week. We have Marshall Cox to talk about Social Security and workers' comp. We'll be back in 2 weeks. Thank you. May God bless and keep you. Make sure you go out and get vaccinated, because the life you save may be your own. Thank you. May God bless and keep you.
Thank you.
Take care.